The liability for a defect in a public sidewalk is governed by the South Carolina Tort Claims Act. A governmental entity is liable for defects in sidewalks and roadways that are part of their street system if the entity was negligent in constructing or maintaining the area, or the entity had actual notice of the defect, or the defect existed for a sufficient length of time for notice to be inferred to the governmental entity. If the entity does not have actual knowledge of the defect in the sidewalk or road, the plaintiff must prove the amount of time that the defect existed in order to show that the defect existed for a sufficient length of time for notice to be inferred. Whenever a client is injured in a fall on a defect in a sidewalk or roadway, we have to identify the governmental entity responsible for maintaining the area, then follow the provisions of the South Carolina Tort Claims Act in regard to the notice requirement, and then finally confirm that we can prove how long the defect was present to show that the governmental entity should have known of the existence of the defect. It's a long sentence. These are complicated cases that turn on this notice requirement and can unfortunately be limited in the amount we can recover due to the South Carolina Tort Claims Act. Call us to discuss your slip and fall, 843-839-4111.